positive. The business looks good. The weather looks a bit better. Yeah, so things are looking much more positive. So yeah, hope you guys doing all doing all right out there. Um, okay, 9:30. I think let's get going. If you have any questions, yeah, please post them in the little box below, and I'll deal with them at the end. So, guys, thanks for joining us today. Thanks for having me. It's always very much appreciated. And if I can also say, thanks so much for the support we get. We really, really appreciate it. If you guys need me or any of my team at any stage, please don't hesitate. Give me a call, drop us an email or a WhatsApp, and always very, very happy to help. So, if you recall it feels like last week, but it's actually last month. We spoke about, some issues around property due diligence, completing paperwork. And what I'm going to do today is I'm going to just continue with property due diligence. And, I'm going to focus on some slightly different issues and some of the same issues. But, again, it's this concept, this idea that if you're going to sell property and if you're going to present yourselves as a property professional, what we want to do is first of all understand the exact product. What are we selling? Are we selling freehold, sectional title, a property in an association? What are we selling? What are the parameters of what we're selling? And together with that is look at what could be the problems in our transfer process, in our sales process. What's going to delay us? What can we do to really improve? What's foreseeable in terms of where we are? Because as I said last month, is the better we prepare to sell the property, and the more effort we put into that, the easier that transfer process is. And of course, guys, the goal is that we need to meet the requirements of being in the referral business. So we're in the referral business, you're in the referral business. If we do a good job, we get more referrals. It's better and better and better for us. And of course, I've learned over the years that, I remember reading an article once about a high court judge who was talking about the conveyancing process, and he spoke about the mysterious ways of conveyances. And I think sometimes people fear that there's the mysterious ways of estate agents and conveyancers, because this process is sometimes so unfamiliar that we really need to guide people. And, the smallest thing goes wrong, bam, people blame you, they blame us, and completely unfairly most of the time. So, we need to sort of, I sometimes feel like I'm juggling, right? And, I'm juggling 50 balls, but if I drop one, I'm going to get lambasted. And that's why we want to try and look in the future and say, well, we know how to do this. What can we do to stop it, and to make it better? So first of all, and I know I've spoken about deed searches for 3 months in a row now, so apologies for that. But they are so critically important. Do the property, do the person deeds office searches, understand the endorsements, look at the nature of the property, look at contractual capacity, make sure that the resolutions are in place. Get the trust resolutions. If you need help, please give us a shout. But not to belabor the point, we have to do those deeds office searches. Guys, title deeds I've also spoken about before. And an interesting thing happened to me in the last 2 weeks. I dealt with some agents in the sort of Craighall area. And what happens in the Craighall area? There's a bunch of, man, it's a multitude of servitudes and right of ways. And what happens was the agents got a mandate, sold the property. We went to conveyances, the property transfer went through and registered. And after transfer came through, the agents and the seller got a lawyer's letter, basically wanting hundreds of thousands of rands worth of damages, because what happened was that the owner discovered that there was a servitude on that property. So in other words, it was a very simple encroachment servitude. But for example, he bought 1,500 square meters of land, but at some time historically there was an encroachment, and the wall was obviously built in the wrong place, and the historical neighbors did an encroachment servitude, and they just, instead of breaking the wall down and moving it, they just really gave the neighbor right of occupation of a portion of the property that was sold. So in other words, the net effect is that the current owner didn't have 1,500 square meters. He had like 1,300 square meters. So the encroachment was about 200 square meters. And he was extremely upset about this. He was pointing fingers, wanting to refer everyone to the Estates Affairs Board. And I was called to give an opinion. I said, look, the guy's got no case simply because in our agreements, we say that the property is sold with all existing title deed conditions. But, there you've got like a clause in every standard agreement of maybe 60 words, but in those 60 words, we're binding our sellers, our buyers, to an entire pages and pages of title deed conditions. Well, maybe one title deed condition, maybe pages that may be onerous, that may not be onerous. And that's why I've always advocated, if you sell freehold property, get a copy of the title deed. You can call us, we'll do it for you. We always get a copy anyway from the deeds office for every deal we do. So you get a copy, you have it on hand, and when you're about to do that deal, as a short disclosure, you email a copy through to your seller buyer and you say, listen, just for your record, here's a copy of the title deed with a delivery receipt on it. Or you give it and you let the guy sign for it. But for me, it's such a simple thing to do. And I must confess, this is the example I've given you now. It's unusual, and in fact, that agency has now made it their policy, and it is particularly because of the area that they work in, to get a copy of the title deed in every single case and to give it to the parties. So that's I personally believe that it just goes a long way. It also for me shows a level of professionalism, and for me, if you hand over the title deed, it really is good going. I must say I don't necessarily think that it's absolutely essential when dealing with sectional title property, but hell, it certainly doesn't hurt, and there are sometimes unusual conditions there as well. The next thing is, in terms of understanding the property that we're selling is, guys, if you're selling sectional title property, you need to understand, get a copy of the body corporate financials, get a copy of the body corporate rules. I know that there's complexes out there who are hundreds of thousands of rands in arrears. And, my view is that if you sell the property, of course, if you have direct knowledge, it needs to be disclosed, but it's simple. Get a copy of the latest financials or a letter from the body corporate. They'll be solvent, hand it over to the people, and there you go. The body corporate rules also, if you sell in a particular complex on a regular basis, I would get the rules and I would hand it to my buyer. And I can't tell you how many times it's happened over the years that what we do is we find that there are, in the sectional title schemes in particular, you sell to somebody, they want to bring their dog or their cat. When they move in or they take occupation, the chairman knocks on the door and says, sorry, no pets allowed. And you know how this happens sometimes. And I had this great example of, and I think it was actually one of your guys' deals. When the buyer was signing the offer to purchase in the house, there was a cat next to him, and he was stroking the cat, and the cat was walking around the couch, as cats do. So there was an assumption that, well, pets are allowed. When he moved into the property, the chairman came and said, look, you can't have animals. There's no pets allowed. He said, what are you crazy? There's dogs. The previous owners had dogs. He said, yeah, but those are legacy dogs. We changed the rules once those guys were there, and we changed the rules to say no new dogs. You have animals or pets, they can stay, but when they pass on, that's it. So we mustn't make assumptions, and that's why I'm saying that these body corporate rules, just one of these areas that create great unhappiness. People love their animals, and it's a very emotional issue. Exclusive use areas we also covered last week, but it's so important to understand what are the exclusive use areas and record them. Special levies, special levies, this is a largely ignored rule by managing agents. But in terms of the Sectional Titles Management Act, if there's a special levy payable installments, in terms of the act, the buyer actually picks up the special levy installments and continues to pay it. So what I advocate is check, are there any special levies? Are there pending special levies? And if there are, deal with it properly and comprehensively in your sale agreement, so that we can, we can deal with it and again avoid those disputes. And maybe it's slightly unusual, but it's, in my view, it's still certainly, does exist, and it does become a problem. And this is all about understanding the property that we're selling, and coming to grips with it. The next thing that I think that I think we need to do is understand the cost of owning the property sold. So if you're selling a straight freehold property, great, get a copy of the rates and taxes account. Please don't rely on your owner to tell you what the rates and taxes are. Get a copy of the account and give it to the buyer. It's also a useful way to determine whether or not there's a massive arrears, as an example. But objectively, you've got rates and taxes, you've got sanitation, you've got refuse removal, you've got those things. It's the same as if you're dealing with a sectional title property. You WhatsApp the owner and you say, sure, well, how much are the levies? And he says, the levy is 500 rand. And you then pass that information on to the you pass that information onto onto the owner, right? So you once you pass the information also onto the buyer then relies on your information. It's 1,500 rand. They proceed, they take transfer. And I've seen a number of instances over the years where buyers after the fact come back and say, you told me it was 1,500 rand. I've now got my levy statement, and the actual levy is 1,500 rand, but there's a garden levy of 200 rand. There's a security levy of 300 rand. There's a DSTV levy of 80 rand. And in fact, when we add up all the levies, it's 2,500 rand. And particularly for investors, that makes a material difference, and really makes people unhappy. And then, of course, you remember, you've got people, they need to live in the property. They might try and claim damages. I've seen that happen before. But I think the worst case is that they now live in a complex you want to sell in, and every single month they get the account and they need to pay that extra money. They think of you, and they think you gave them the wrong information. And that is exactly the scenario that we don't want to have. If you're dealing with homeowners associations, get the levies for the homeowners association, and get a copy of the rates account. So it's really important to be absolutely accurate in giving this information. It's not. I don't believe it's enough to simply give it over in a relaxed way. It needs to be done properly, and it's also a nice way to get the information. Bear in mind, guys, that even on your sectional title statements, I've seen cases where owners have told agents that they own a particular parking bay. When they get the levy statement, we see that the owner is actually renting it from the body corporate, and that in itself is problematic. The next issue I want to deal with is the National Credit Act. Guys, you must remember that in terms of the National Credit Act, the banks are entitled to charge 90 days in lieu of interest, in lieu of your cancellation. So if you have a property and it's worth, and your bond installment is 20,000 rand, then when we call for cancellation figures, the bank's going to add on 90 days. So it's 20, 20, 20 in 3 months. They're going to add on 60,000 rand. Now, if I register at the end of the 3-month period, well, then the entire portion falls away. If I register after 60 days, the 1/3, the 20,000 rand, is lost. It goes to the bank. It's gone. So it's always a great idea to get your clients, your sellers, to notify the bank in writing that that they're going to sell their property, and they give notice. So what happens then is the 90 days starts running whilst we are marketing the property. And I always give this example. You bring me a beautiful deal, 4 million rand, no bond. No bond to register. The money's going to come to my trust account in 15 days. I can register that matter in like 4, 5, 6 weeks. But now I call for cancellation figures, and the seller says, whoa, I'm not losing 120,000 rand, or I'm not losing 80,000 or 40,000. So I delay the transfer, and it is simply useful to have that to have that 90 days given early. And remember, it's not good enough for the guys just to phone. They must phone, get confirmation, because when I call for cancellation figures, we actually need to understand. We need to go to the bank objectively and say, someone gave notice. We don't want to wait the full 90 days. Please don't make us wait. Rates clearance certificates. If you think about my comments from 2 slides back of getting the actual rates accounts, we found that there are rates problems, and COJ, for all the flack that it takes, actually works very well. And people may slate me for saying that, but thousands and thousands and thousands of people get their bills, they pay their bills, there's no problem. The problem with COJ and with Ekurhuleni and all these municipalities is when there's a problem, it's not so easy to resolve and it takes time. So I suggest as a matter of practice that what we do is in the marketing process, we get copies of the people's rates accounts. You hand them to us or you go through them yourself, happy to do it for you, and you make sure that all the charges are there. So to give you a simple example, if the refuse removal is not on the account, all right, that can take a long time. First of all, when I apply for rates clearance figures, they do a bit of a due diligence to make sure there's electricity, water, sanitation, refuse removal, etc., etc. Is it all there? Great. Now we issue you with your figures. If it's not there, they won't issue you with the figures. Now we're just going to resolve the problem, and now we're looking at a potential delay. And depends on the problem, depends on the delay, also depends on which municipality. But the bottom line is, it's easier to pick up these issues during the course of the marketing of the property, and start corrective action and resolving the issue whilst we are marketing the property, rather than wait to sell the property and then find out that there's a problem and then discover, well, then, wow, we have this delay. Okay, so the last slide I have, and the last point that I wanted to make, deals with special powers of attorney. And again, this is one of these issues where we need to understand that when our sellers don't reside in South Africa, or when we know our sellers are going to immigrate or they're going to travel a lot, well, what we need to do is we need to look very closely at their circumstances, because if they live in a different country or they're going to be living in a different country at the time that we do this transaction, signing documents overseas is very onerous. And let me just break this down though. If we're going to sell, if we're going to have a sale agreement, you can email the sale agreement, sign overseas, scan, email back to us. Legal, no problem. The special power of attorney is not necessarily for that purpose. The special power of attorney is for the purpose of signing the conveyancing documentation. So if I'm a sign conveyancing documentation and I need to send it overseas, there's a process that it needs to follow, and that process is, if you part of certain countries like the UK, Botswana, those types of countries, you can sign at an embassy or you can sign at a notary, and there's not too much formality to it. And even that is it's a challenge for some people to get to the embassy. If you sign in a country that's the Hague Convention, well, then what you need to do is you can sign at the embassy or a notary, but your notary needs an apostille certificate, and an apostille certificate authenticates the notary standing as a notary in that country. It's an additional step. It's challenging. And if you're not part of the Hague Convention and you're not part of one of the designated countries, well, then you have to go to the embassy. And as an example of this, we had clients in China, and quite literally, the poor lady had to wake up at 4 o'clock in the morning and catch buses and trains and I don't know what all to get to, I think it was Beijing, to go and see the actual embassy. That she doesn't live close by, we sometimes have clients in for example, the United States, where also there's no embassy close by. They say to us the closest embassy is like 4 hours away. So these things become truly problematic. So what would be the solution to this is, well, we if they're here, get them to sign the special power of attorney while they are here. If they're overseas, well, then what we can do if we want is we can get them to sign a special power of attorney during the marketing process. But remember, it is, of course, a lot more beneficial and easier if they are here in South Africa. Because remember, if I'm going to get them to sign a special power of attorney overseas in the marketing process, I can do it, but they must still go to the embassy. So my view is, well, they may as well go and sign their conveyancing documents when they get there. But that does depend on timing. Just a word of warning around the special powers of attorneys is, often people say to us, we've got a special power of attorney, so don't worry about it, or we have a general power of attorney. And everyone says, great, that's good news. Once the deal is done, um, they then give us the special power of attorney. And the problem is, it was drawn by the wrong attorney, the wrong conveyancer, or they simply drew it themselves, or they bought a CNA version. And now what happens is it doesn't meet the requirements of the deeds office. So the deeds office has very specific and specific requirements. So what we say to people is, if you have a special power of attorney, or if you have a general power of attorney, give it to us. Give it to us during the marketing phase of the property. Give it to us so we can have a look and we can actually see what it looks like. Is it going to be acceptable? Do we have the original available? Can we work with it? Yes or no? Great. Then let's do it. Because if it doesn't work, then what I'd rather do is I'd rather draw that special power of attorney for the clients while they are here. And guys, please remember, we don't charge for this. We don't charge for it. It doesn't take us massively long, but it is simply a process that needs to be followed. Yeah, and just to reiterate the point is that the deeds office has special requirements. It must be signed correctly. What I sometimes also do is I have clients give me a special power of attorney if they don't know anybody else, and what I do is then I operate that special power of attorney on their behalf, and I'm very careful with the way I deal with this. I won't sign any documents from them unless I email them. They confirm the documents are correct and it comes back to me. So again, the point to be made is sit down with your clients, buyers and sellers. Where are you? What are your intentions? Do you travel? Are you going to immigrate? Where are you going to be? If necessary, let's get the special power of attorney and let's get it drafted straight away. Okay, guys, that's my talk. I see that I was pretty quick this morning. I've got a few minutes left. There's topics that I've covered before, so I see that there's no questions. Hopefully I did a good job. Michelle, are you there? Just a question there. The question is, do you have to notify the bank every 3 months in terms of the 90-day notice period? Most banks would accept that if you give them notice, and you go over the 3 months, they won't make you start again at day zero. But having said that, the banks, and we've tried over the years to try and keep track of the bank's policies on this, and we actually have a document in our property manual that sets out the various banks' approaches to it. So the best way to do it, and the safest way to do it, is give your notice, diarize for 3 months, and then just go and give the notice again if you haven't sold the property. So yeah, I think that's the safest way to do it. Who is responsible for special levies after the buyer buys the property? It's a bit of a contentious point. If the special levy was raised prior to the offer to purchase being entered into, and it's a once-off special levy, well then the seller must pay it. If the special levy is raised before the sale of the property and it's in installments, the law says that on registration or transfer, the buyer is going to take over that levy. Now, of course, that creates a massive amount of unhappiness unless everyone properly understands it. So in my view, one wants to regulate it and write into the offer to purchase. Cool. The seller is going to settle the special levy up in full as the date of transfer. Alternatively, the buyer is going to take over the special levy. What I've seen is that most sellers take the approach. Most sellers take the approach that so most managing agents take the approach that they just take all the money from the seller, and it in fact sometimes becomes a bit of an argument between the date of sale and the date of registration. If there's a special levy, and this is really the issue, and this is where it becomes an arguable point. And what I try and do in my agreement is I try and deal with this, and I try and say, if the special levy is raised between the date of sale and the date of registration, and if it's in respect of past costs like a historical water bill, the seller must cover it. If it's in respect of future painting of the units, well, then it's for the benefit of the buyer, and then the buyer must pay it. But the problem with those arguments is that they're really totally imperfect, because if I'm the buyer, I could say, well, why should I pay the special levy going forward? Because for painting, because the law says that the body corporate and the seller are supposed to have a slush fund, a contingency fund to cater for these issues going forward. And that's the problem, is it becomes arguable who is liable. As a default position, I'm going to say the seller, but it does really depend on the circumstances. But this is also why I try and emphasize this point, that we need to engage with our sellers and say, are there any special levies? Please give me your levy statement. I would phone the managing agents, have a chat to them. What I've seen in the past is, and I'm guilty of this myself, is that of some of the investment properties that I have, they have an AGM, and the AGM says we're going to propose and discuss a special levy. Then the seller doesn't read it, because he doesn't attend the AGM. He doesn't read the documents, just lets it happen as it happens. And we've had it before, where there's a special levy raised, and the seller says, but I wasn't aware of this. I knew nothing about the special levy. I couldn't make disclosure. And then what we do is we go to the managing agent and say, well, listen, we've been discussing this for the last 2-3 years. This owner just doesn't pay attention. So it's only I'm answering your question in a very imperfect way, but because of the possibilities here. But I think that the real answer is engage your sellers. Is there a current special levy? Do you know of any pending special levies? And then record that. If there is a special levy, deal with it comprehensively in the seller agreement as a special condition. So the last question: if a property liquidated, when do the deeds office add an attachment to the deed? So properties don't get liquidated as such. What happens is people and companies, companies get liquidated and people get sequestrated. Alternatively, companies and property owners, whether you're a company or an individual, you have a judgment taken against you, and then your property is then attached. So if somebody is sequestrated or a company is liquidated, there should be a liquidation notice filed against the company, against the property at the deeds office. So if I do a deeds office search, I should see a little interdict under your endorsements column, and it should then show that there is that this property, this person has been sequestrated. It's unfortunately not a perfect system, because we come across various cases where we deal with people who've been sequestrated, and there's no notice at the deeds office. So partially the way that is countered is that when people come in and sign documents with us, one of the documents, if they're an individual, they sign and say, I have never been sequestrated. They must sign an affidavit to say, I have never been sequestrated, or I have been sequestrated and I've been rehabilitated. I have been sequestrated and I'm still unrehabilitated insolvent. Same for a company, where we get them to sign a document, an affidavit, as part of our conveyancing documents, to say, well, this company is solvent. It's never been placed into liquidation, and there's no pending liquidation applications. So the reason why we do that as conveyancers is because it affects contractual capacity, and we need to protect ourselves to have on record what the client has told us. My experience is most buyers, that we know of, they do come, when they come here and they must sign this affidavit, we say, this is to confirm I'm still solvent. And then they've been sequestrated. They say, oh, no, I've been sequestrated. And then we have to deal with it. But yeah, I mean, and of course, the other attachment possibility is when there's a judgment and there's actually an attachment on that property. And once the property's been attached, if I do a deeds office search and there's nothing on the endorsements to show that there's an attachment, the property is clean, and I'm going to go for it. So Paul, just to finish it off, you're quite right. If you do a deeds office search and there's nothing under endorsements, then there's no indication on the title deed that either the property has been attached or this person has been rendered has been sequestrated. Okay, guys, so good timing with your questions. Thank you very much. You've taken me to exactly 10 o'clock, well, just before 10 o'clock. So, well done. And yeah, thanks for joining me. I hope it was a useful discussion for you all. And yeah, good luck in the next week and month for your selling.
Thanks so much, Marius. Much appreciated.
Yeah, I think it pleasure. Nice to see you, Michelle.
Short, but it did add a lot.
Michelle, not sure if it's you. Yeah, no, thanks. And I actually, when I did the presentation, when I prepared for it, I thought I often try and cram so much into it. Decided to just try and slow down a bit and get it right. Anyway, guys, I'll leave you guys to it. Michelle, thanks so much, and guys, thanks for your time and watching, and yeah, and good luck. Thanks, guys. See you later.